Welcome to TOOP TV's newest segment, Fireside Chat. The original Fireside Chat was a regular radio show used by presidents to inform the public of the latest issues. It originated in 1933 and ran until 1944. But now the Fireside Chat is back and we're using it to tell you about the latest real estate issues. It's uninterrupted interviews with the experts in the know. So sit back, relax and enjoy Fireside Chat.
Welcome everybody to this week's edition of Fireside Chat. Christmas is just around the corner, and you'd always know it's Christmas when our weekly magazine comes out in bright colours like this and a whole montage of the whole year, 50 editions so far, and the covers. Some great historic stuff there with Tony Pilkington on the front. Of course, Tony's heading to Sydney. We've also got Gavin Wanganeen's house. Inside the book, we have also a countdown of our various editions of our magazine and the different names, and of course, a great magazine to flick through when having a coffee. Even if you are electronically savvy, this is still a lovely publication to pick up. One more to go for the year. This is the second to last one. Some gorgeous properties. Be sure you pick that up. Now today we're covering off on something extremely topical. Swimming pools in backyards and safety. There's been a lot of legislation changes, and to that end we're going to go through what they are and how they impact on you as a seller, and of course for those of you who are purchasing. Now, to be as our expert here today and to be the one that's going to fill us in on all of the gaps and the latest, it's Mr. Chris Gill from Courses Lawyers. Welcome, Chris.
Good morning, Anthony. Thank you for having me.
All right, pleasure. Now, Chris, tell me first of all, a lot of people in the old days used to call you brokers, and then there's solicitors, conveyancers, and all the different terminology. Just explain to us what in 2010-11, what's the deal with what you do?
Okay, conveyancing, land broking, one and the same business. Previously we were known as land brokers, and to keeping with all the national legislation that we all seem to be coming under now, conveyancing and conveyancers are a national recognised title and effectively replaces the old title of a land broker.
Now this is why it's confusing though, because you're conveyancer but Courses Lawyers. So how does that work?
Okay, with a lot of law firms elect to choose conveyancers. Conveyancers are specialists in property-related issues. Whilst lawyers can also do conveyancing, they would traditionally handle the more complex issues and contractual disputes that happen between parties. Conveyancing is procedural. It's a matter of complying with the Real Property Act and getting documentation specifically in relation to lands titles information. We'll also prepare documentation as well, contracts, and deal with issues until they get to the stage of conflict, in which case a lawyer would take over.
Right. Now there's two big subjects that I'm wanting to cover today. One is the Form 1, which is the forms that are given to a purchaser, signed by the owner of the property, telling them about their incoming purchase. And the second thing is the safety and the pool legislation that's changed and how it impacts on both the buyer and the seller, and whether it impacts on a tenant and a landlord. So first things first, there's been a lot of complex property legislation put in place over the last few years, and it's got to the point where the salespeople in the field basically seem to have almost got out of their depth in producing those forms. Tell me about your take on Form 1 and exactly what it is for people who haven't been exposed to it.
Okay, for a contract and a sale of a property, there's two parts. There's the contract, which has always been done by the agents and will continue to be done by the real estate agents. And then there's the more complex Form 1, which is a vendor disclosure statement. The purpose of the Form 1 is to provide the purchaser with relevant information required by statute so they are fully informed as to what they're buying. So it details things like mortgages to be discharged, easements against the property, council approvals, anything that may affect their decision to purchase the property. A couple of years ago, 1998, there were some fairly significant changes to the Form 1, and basically the legislation has now become sufficiently complex and risk-driven for a vendor that the outsourcing of the Form 1 is becoming a fairly common practice within the real estate industry. Conveyancers and lawyers are specialists in preparing a Form 1. A real estate agent is a salesperson, and that's their specialty. Yep. They're there to sell the property.
Realistically, the profile of a salesperson is so not the profile of someone who would be filling out these forms, isn't it?
Certainly, yeah. Back when it came in 1974, the forms were very basic and simple. Over time, they've become more complex. And the vendor is at risk if there's a technical mistake made on a Form 1.
In fact, most of the reasons that contracts have been avoided has been based on a faulty Form 1, hasn't it?
Certainly. And most of the issues with Form 1s are negotiated and don't get to court to give good precedent for law. So we've got some limited precedents. If you have a very minor technical fault on a Form 1, it could be that a mortgage isn't discharged or isn't noted or to be discharged, then the whole transaction can fall over, and that could happen the day before settlement.
So, Chris, there's a current trend now that's in place as we speak, where people are moving, the salespeople realise they're out of their depth across the industry, and you've set up a company specifically for that, as have other conveyancers.
Yes.
And how does it work with you?
Okay, we've set up a company called the Form 1 Company, which employs people specifically to prepare Form 1s.
So just totally specialised?
Totally specialised. And what we do is we prepare the Form 1, we liaise with the vendor to obtain all the correct information, interpret the legislation and the information that's provided by the various government departments to complete an accurate Form 1. And we do that on behalf of real estate agents. And in effect, you've got a conveyancer checking forms, making sure that the transaction is correct at the time of signing contracts.
Now, if it's so tough for the vendor or the seller and for the agent to get their head around it, don't you find that a bit weird, because it's probably equally as difficult for the buyer to understand it?
Certainly. Now, buyers could not possibly understand a Form 1. If you present them with a document that can be up to 400 pages thick, and it's full of technical information, there's no way they can understand it.
So just a shot across the bow at the legislators. When I first started in real estate, Form 1 was 1 page. The equivalent was not called that. And it just told you in very basic terms whether you had easements across your land or whether the next door neighbour had his fence on your property. Now it's gone into all sorts of areas like land rights, it's gone into environmental issues. Do you think they've completely lost the plot, the legislators?
I think the information is required to be provided, but I think the transposing of information from a government provided document into a statutory form allows the error factor to be increased significantly.
So why wouldn't the government departments just send through their information, put it together and just centralise it and have everybody access that on any property at any time?
It would be a sensible approach. The idea of a Form 1 is to set up a cooling off period for a purchaser. They get a statutory 2 business days to consider their purchase, to seek advice from conveyancers or their lawyer as to the documentation. It almost should be compulsory to seek that advice during the period of the cooling off period. In my experience, maybe 10% of people bring their documents into us whilst they have the opportunity to withdraw from the contract.
Right.
If they purely gave the searches and allowed it to be interpreted by the professionals, we wouldn't have the issues that we've got with Form 1s.
Okay. And the other thing with auction and tender, presumably there's no cooling off period with that, so you need to do your homework beforehand.
Certainly. With a tender, you get provided with a tender document which should include all of the contracts and Form 1s. Seek your advice before you submit the tender. With an auction, the documents are on display 3 business days before. You have the opportunity of reviewing the documents, having someone look it through, and then at the time of auction, you should be fully versed with the property.
Okay. Now, to finish on that subject, your best advice to a seller is?
To outsource the Form 1, or at the very least, at least have it looked at by your lawyer or conveyancer before it's used in the sale documentation.
And your advice, if you're listening and you're a seller? You're a purchaser?
You're a purchaser, you have a cooling off period, you have the opportunity to waive that cooling off period. Make sure you receive your advice whilst you're in that period of consideration. If you allow the period to lapse and then you find out there's an issue, you may not be protected by the legislation.